How can a pretrial motion to suppress be used to exclude your confession from trial? The answer to that question is coming right up after this. Welcome to Gustitislaw. If you're new here, I'm Steve Gustitis, and this is my channel. If you're interested in learning how to effectively navigate the criminal justice system, how to manage encounters that you may have with the police, and how to defend criminal charges, then consider becoming a part of the Gustitis Law community. You can do that, and it's easy. Just click on that capital black and white G down in the lower right-hand corner of the video screen. If you have comments, if you have questions about the video today, add those down in the comment section and I will be happy to respond to those. And don't forget to give us a thumbs up if you like today's video and share that video on your other social media platforms. Today's video is number 4 in our series on pretrial motions, and links to other videos in the series can be found down in the description section below. A confession is one of the most damaging pieces of evidence that the criminally accused person will ever face. Number 1, a confession typically proves a person's knowledge, a key element in the prosecution of most criminal cases. Number 2, it's evidence that comes from our own lips, evidence that we had control over. And number 3, juries typically believe confessions. A confession is simply a gift to the prosecutor handling the case. However, sometimes a confession can be suppressed from evidence if it was obtained in violation of the law. For example, if the police stop and detain you illegally, that is, if they stop you without reasonable suspicion, without probable cause, and without your consent, then evidence derived from that illegal stop and detention can be suppressed from court, including your confession. We discussed the motion to suppress evidence in this regard in a prior video in this series. A second way a confession can be suppressed is if it's shown that the confession was not voluntarily made. An extreme but simple example would be a confession made at gunpoint. Certainly, that statement made by the accused was not made of their own free will and accord, and would not be admissible in court. Another example of an involuntary confession might be where the police threaten to take a person's children away from them unless they agree to give them a statement. Again, this is an involuntary statement and can be suppressed from evidence utilizing the pretrial motion to suppress evidence. The most common way to attack the admissibility of a confession is by utilizing the doctrine set forth in the case of Miranda versus Arizona. Under the Miranda case, if the police have a suspect in their custody and they plan on interrogating or questioning the suspect must be read their Miranda rights prior to questioning, and the suspect must agree to waive or give up their right to remain silent. If a suspect in custody is not read their Miranda rights prior to being questioned and interrogated, the statement or confession of the suspect can be suppressed utilizing the Fifth Amendment to the United States Constitution, again in a pretrial motion to suppress evidence. There may be other ways a confession can be suppressed from evidence at trial. If you have questions about your own case, then discuss those facts and circumstances with your criminal defense lawyer to make a decision whether or not to pursue a pretrial motion to suppress evidence. If you have questions or comments about today's video, add those down in the comment section below, and I will be happy to respond. Don't forget, if you liked the video today, give it a thumbs up and consider subscribing to the Gustitis Law community. Thanks again for watching our series on pretrial motions practice, and I look forward to seeing you next time here at Gustitis Law.